Hello and welcome to our webinar today. I can see we have quite a few attendees with us from different time zones, and it's been quite a tricky one given the subject matter to fit in. So I'm grateful that you've all managed to make it. So good morning, good afternoon, and even good evening to some of you. Thank you very much for joining us today. For those of you who are new to our webinar program, my name is Vin Banj. I'm the international co-chair of our technology and data practice here at Taylor Wessing, and I'm delighted to bring this webinar to you. Regular attendees will be very well aware of who I am, but I ought to at least put on here my obligatory slide and profile so you can see my picture again alongside me in real life on the screen, and also a little bio about me. This continues to be an exciting time for us all as practitioners, but also as clients, because there are so many different areas developing around data privacy. Barely a day or a week goes by without a new development somewhere in this world, and that's why we wanted to bring you this webinar today, as we've seen this very significant development around data laws in China. And at Taylor Wessing, we have a very strong data protection practice, a very strong international team. And so I'm grateful that I'm joined by my international colleagues today, Michael Tan and also Julian Sun, who are going to be presenting today. And just to show you that they're real people with their own bios, I'm just putting their slides on screen so you could see them here as well. Both Michael and Julian are based in our Shanghai office and very much used to guiding our clients and our international businesses through the complexities of regulation in China. And obviously data and cyber and security are a key focus of their practice as well. So we're going to be talking to you about a couple of things today. I say we because actually the real experts here are Michael and Julian. So in a moment, I'm going to hand over to them, and they're going to be walking through these very new and important developments that we see coming out of China. And then once Michael and Julian have talked around the key areas that they want to bring you up to date on, what we're going to do is then just flip over to some polling questions. And again, if you're a regular attendee, you'll be well aware of our polling questions. They are anonymous. They allow us to present that aggregated view so all our attendees get the feel for the answers on those questions, and you can see how others are positioning themselves against some of those key questions, which I think is quite useful for everyone to share and be a part of. We'll opine on some of those polling questions as you click through, but also we'd be delighted to have more of your questions as well. We've already had some questions sent through, and I shall be posing those questions to Michael and to Julian. So if you have more questions, please do use the Q&A facility that exists, and you'll see it on your screen. Send through those questions, and time permitting, we will get over to those as well. And despite the title being a slightly flippant title around whether or not these new laws in China will be the new GDPR, I think it's quite easy for us sometimes to forget that it is actually quite a big world, even though we think it's a small world, and sometimes we have examples where we feel it's a small world. It's a big world, and there are lots of data laws as we're seeing in this big world, and lots of big laws with impact at a very local and extraterritorial context as well. And so there are lots of ways that we could potentially phrase the title of the presentation today, but we want to try and explore what this new law looks like, what it feels like, what sort of obligations are imposed, and what's different and new compared to GDPR as well. And then we'll toy on that a little bit later with some of the questions that I know have already come through as well. So we could muse on the title for a lot longer, but we're not going to. I want to give you the substance of today's presentation. So let me now hand over to Michael and to Julian to lead us through today's update on China's new data laws and also the new developments on cybersecurity law. So enough from me. Michael and Julian, over to you.
Thank you, Wayne. Hi, everybody. Good morning, good afternoon, good evening. Greeting from Shanghai. So very delighted to have this chance to share with you our observation and well, so far experience pickup out of practicing data laws in China. We have been watching upon and practicing this topic for already several years, although now the unified framework was just rolled out this year, but there have already been quite a lot of efforts in the past. So before we run into all the technicalities, usually we would like to pull you back a little bit just to have a quick look at the bigger picture, which will help you to better understand the legal regime in China regarding data protection. So the first thing you need to know is that here you can see that I'm trying to stress a bit of some political agenda of China. Why? Because presumably, and that will mean that usually you will start from a privacy perspective to try to understand what's going on in China. However, being a quite different society organized in a different way, politically speaking, there are quite some different implications which you also need to bear in mind when you are talking about data protection in China, which then may help you better understand that in general, under PRC laws, as far as we talk about data protection, there are always two dimensions to bear in mind. Number one will be privacy protection. This is very similar to what you are used to under GDPR. The other aspect would be national security. This is very much important also in the Chinese context, which you may not necessarily have in Europe. Although now, only in recent years, I think Europeans are also trying to follow up on that aspect. So having a look at the slide here, this is the opinions from the top ministries in Beijing, which actually was also driven by the political ambition of the top leadership, that they try to develop certain strategical industries where China would like to have strengths globally. Some of them, China already are pretty strong. And if you read them through, you may see that actually many of those sectors where China has an ambition are all data rich or closely linked up with data. And this will mean that in the long run, data is going to be a very important topic on the Chinese political agenda, as could be reflected by the very frequent and rapid legislative efforts in recent years. And on the right box, you can see that data is even being designated as the fifth factor of production, together with the other economic resources. So this will mean that actually whatever concerning data, this now receive top political attention. And good thing is that you may see more legislation in that regard. On the other hand, it also means more regulatory burden for multinational companies operating in China or dealing with China. And one important feature to bear in mind is that this is an evolving system. So it's still not yet comparable to what you have in Europe because GDPR have already been there for many years. Even before GDPR, you have the EU directive on data protections. So in many aspects, China is trying to learn and also copy quite a lot of concepts under GDPR, regarding which my colleague Julian will guide you through later on in more detail. And a lot of framework mechanisms and concepts brought by the Chinese legislators and regulators obviously may not necessarily have been thought through. So you should not feel surprised that whenever you are digesting any new China data-related laws and regulations, you will quite often find a lot of confusion, ambiguities, and even some conflicts under the rules, which is not unusual, also as in many other legal areas in China. So in general, no comprehensive legal regime around data yet. However, there have already been a lot of tools being built up. And then start this year, now for the first time, ever unified legal framework, which is we call it PIPL, Information Protection Law. More or less is the GDPR. Besides this law, there are also some other laws, like the security law, like Korean cyber security law. You might confuse the concept, the titles, but indeed, as can be seen from last year, you see many concepts regarding data, as shown here. And as far as we talk about policy, what you need to recognize difference that under the time PIPL, the terminology used is personal information instead of personal data, but it's more or less the same thing. So I'm moving to the next slide. Just 1 second. So it seems not moving. Well, the slide is not moving on my screen. Just 1 second. Can somebody help me to move the slide? So you just, Julian, can you help me to move the slide to the next one?
Let me try. Do you mean this one, the legislative development?
Yeah, okay.
Yep.
So this is a chronicle showing you the latest legislative development. So few milestones to note. In 2017, we had the cybersecurity law, which made quite some noise on Western media, because everybody was alleging that China was trying to prohibit data from leaving China, which actually was not true. It was wrong based on some wrong interpretation of Article 37 of the cybersecurity law at that time. However, that was start of the efforts to build up a more comprehensive data protection framework. And then things drag on. There have been a lot of draft rules by the regulators. Many of them have not become materialized, remain as a draft, but the business circle have already been following. Everybody was offering more rules on the privacy sector. However, nothing really happened. On the other hand, 2020, two new laws that was presented. One is the security law. The other one was the personal information protection law. These are the two which replace the two dimensions I just mentioned. One concerns national security, other one concerns privacy protection. And this the legislative process of these two laws was very quick. So they after 2 weeks, and they came into effect. Law took effect on the first, and the personal information law took effect first. In more about these two laws, I'm trying to slides. So it's again not moving. Yeah, Julian, I think I will just hand grant this one to you, the personal information protection law.
Okay. Thank you, Michael. Good morning, good afternoon, and good evening to all our audience. And thank you very much for attending this session. For this part, I will briefly introduce some more technical topics under the PIPL, the Personal Information Protection Law, and also with some comparison with the GDPR, which presumably you are quite familiar with, so that you can get a better feeling and understanding on what's the major difference of the PIPL and the GDPR, and what are the particular issues you need to keep in mind when dealing with data protection matters related to China. So first of all, the law has already become effective from November 1st this year. The first topic we would like to draw your attention is the liability issue under the PIPL. So as you can see from number 1 on this slide, the PIPL adopts a quite similar approach on to the GDPR on the fine which could be imposed to the companies who violate this law. So in general, it will impose a fine up to 50 million RMB in normal cases, which seems to be a little bit lower than the counterpart under the GDPR. But you can notice that in some very extreme cases, the PIPL could impose a fine up to 5% of the turnover of last year, which is even a bit higher than the 4% under the GDPR. So this means that this law could really hurt if you violate it. So this is the first thing we would like to draw your attention to. And on the other hand, personal liability could also apply under the PIPL on top of the corporate level of liabilities. So that means in the case of violation of the PIPL, the senior management of the company, including the legal representative, the general manager, the DPO, depending on the specific case, could be personally liable for violating this law. So they can be personally be subject to fines, and in serious cases, the fine could be up to 1 million RMB. And more importantly, the concerned senior management, the concerned personnel could be prohibited from acting as senior management for a certain period. So this could also have substantial impact on the management of your personnel globally, and especially for your business operation in China. So this is the second level of liabilities you need to bear in mind. And thirdly, on top of those administrative liabilities, criminal and civil liabilities cannot be fully excluded under the Chinese law for violating the PIPL. And in some cases, the company could be exposed to a class action, which is quite similar to the concept under the US law. So that means not only the person directly infringed by the violation of this law could sue you, so other persons who might be affected for the violation of the PIPL could also bring a lawsuit against the company and also its senior management. And number 4, violation of the PIPL could also be recorded on the social credit system. So actually, this is a very political-driven system in China, which is fairly new and is also developing recent years. Blacklisted in the social credit system could have some impact on the future development of your business in a very broad sense, which means that in case you have such a record of violating the PIPL, it could also impact your future business development in China, including loan from the bank or local government. So this could fund impact, which you need to keep in mind. Oh, sorry. Let me move to the next slide. Yep. On the other hand, the Longreach approach adopted by the PIPL, which is quite similar to the GDPR, could also apply for those who operate offshore, meaning that you do not have a presence in China, but you are actually providing products or services to Chinese customers, or you directly analyzing the behavior of Chinese citizens, Chinese natural persons by using their personal information, even if you are doing all this offshore. So under this kind of situations, you could also be caught by the PIPL due to the Longreach approach adopted by the PIPL. So this means that not only your onshore entities could be caught by this law, your offshore entities and even your headquarters outside China could be also caught by this law if they violate the PIPL. So there could be also other topics, issues under the Longreach approach, including the retaliation clause, including some restrictive or prohibitive list which will be published by the Chinese authorities for those offshore entities who violate the PIPL. On this slide, you can see a very brief comparison between the PIPL and the GDPR on the scoping of the PI, personal information. So basically, the concept of personal information under the PIPL is quite broad and similar to the GDPR, generally covering all types of personal information you can imagine, including the name, contact information, your biological information, your ID card number, your passport number, etc. A lot of things can be covered by this concept. Exception to the personal information is also provided by the PIPL, only to anonymized information, which is also quite similar to the GDPR. What's the most different, what's the most significant difference under the PIPL is the concept of the so-called sensitive personal information. Under the GDPR, there's no similar definition, but there's a quite similar one called the special type of personal information. But under the PIPL, the law directly provides a very specific type of personal information called sensitive information, which generally covers biometric information, religious belief, and a lot of information which includes financial account information and information of minors under the age of 14. So for this special type of personal information, the PIPL provides special rules for the processor to observe when processing these special type of personal information. I will briefly explain this in the later slides. So for the principle of PI processing, generally, the definition of processing is also very broad, including all processing activities, including collection, storage, processing, and even deletion. So for processing of personal information, you generally need to follow a lot of general principles, including lawfulness, legitimacy, transparency, and most importantly, under the Chinese law, you cannot jeopardize the national security and public interest of China. This could also apply to those offshore processors, including the offshore entities and headquarters. So this will be a very vague, but also a very important principle under the PIPL you need to follow. Regarding the data storage limitation, so far there's no very specific or precise retention period specified under the PIPL. But the law just provides a very general principle, meaning that you can only store the data for the minimum period necessary to fulfill the processing activities. So this also could leave a lot of room for interpretation by the Chinese regulators, which needs to be assessed and revisited dynamically. As I just mentioned, processing of personal information could be subject to some special processing requirements under the PIPL. So here we would like to draw your attention to the two topics. First is called the separate consent requirement. So this is something that does not exist under the GDPR. So literally speaking, separate consent means for certain processing activities, as I listed on this slide, you need to obtain, literally speaking, a separate consent, meaning that such consent should be separated from the general consent given by the data subjects on processing of, for example, those non-sensitive personal information or non-sensitive processing activities. So separate consent could apply basically when you are transmitting personal information to a third party, you are exporting those personal information to offshore recipients, or you are processing sensitive personal information. So these requirements should be followed when this situation applies. And the second requirement is the so-called impact assessment report. So this could apply in many cases, including the processing of sensitive personal information, including automated decision-making, and also export of personal information. So as you can see, processing of sensitive personal information and export of personal information could be subject to both requirements. And based on our experience, this could be the most common situations you need to deal with when processing the personal information of Chinese data subjects. Regarding the PI export control, actually, this is not a new topic or new concept under the PIPL. In fact, back in 2017, the cybersecurity law has already provided some requirements on data export, but the application of these requirements is very limited under the data security law. But under the PIPL, it now provides a more detailed guidelines on the preconditions you need to fulfill before exporting the data out of China. So that means you need to fulfill at least one of the 4 requirements I listed on this slide before you can export the data. This could include passing the security assessment organized by the authorities, or obtain the protection certification by special agency, or concluding a standard DPA with the offshore recipients, or based on international treaties to export the personal information. So currently, how to implement these requirements to fulfill these preconditions still remains quite vague, which the PIPL itself cannot give you a very clear guidelines. So the corresponding guidelines and rules are still to be formulated by the Chinese authorities, so which who are also constantly learning from practice. So this will have some significant impact on how you can manage export of personal information in a compliant way under the PIPL. So this includes what the standard DPA should look like, how the security assessment should be organized, and how such PI protection certification should be organized remain to be formulated and clarified by the Chinese authorities. Before you export the personal information, you need to comply with also the 2 preconditions as I listed here. First, you need to obtain the separate consent from the data subject. And secondly, you need to disclose a lot of information, including the contact detail, the processing rules, and etc., to the data subject before obtaining the separate consent. So this could be a little bit cumbersome, but on the other hand, as long as you can fulfill these requirements, you could still export the personal information you collected from China. Another topic we have been constantly be asked by our clients and our friends is about the onshore representative and the DPO. So first of all, for those who do not have any presence in China, but in practice, in reality, processing personal information from China, they need to appoint an onshore agent or a representative for managing the data protection issues as required by the PIPL. On the other hand, for those processors who process personal information beyond the threshold formulated by the Chinese authorities, they also need to appoint a DPO to specifically manage the protection of personal information. So this appears to be a quite similar concept and requirements to those under the GDPR. But you can also see from this slide that a lot of detailed requirements, including qualifications, including the privilege, including very practical questions like whether or not the DPO should stay in China. A lot of very practical, detailed questions are yet to be clarified by the regulators. So as you can see that there are a lot of uncertainties under the PIPL, which yet to be clarified by the regulators via some new guidelines or some templates which needs to be formulated at the in the near future. So generally, we would encourage you to keep an eye on the dynamic development of the Chinese legal regime for protection of personal information to help you stay compliant with this law. So that's the introduction of the PIPL, the Personal Information Protection Law. And now I hand it over to Michael to give you an introduction of the data security law, which is also a very important aspect under the Chinese data protection regime.
Thank you, Julian. Thank you. Apology that I have to turn off my camera so you cannot see me, just to ensure the connection will work, at least for audio. Data security law, as mentioned before, that the national is closely linked up with national security concern. This topic or this dimension should not be underestimated and ignored because the European GDPR is too much focusing on privacy protection. In the Chinese context, national security becomes quite a critical aspect to be considered, which will also have quite some impact on multinationals' compliance efforts on the ground, and even with, outside China. So a very brief nutshell about this law. I'm not going to talk too much about this, but just those key points. So the law took effect on September the 1st of this year, even earlier than the PIPL, the Chinese GDPR. And there are also penalties under this law. So the maximum penalty will be 10 million. It sounds a little bit less than the Chinese PIPL. However, don't forget that they also may suspend or even close down this according to law. This is something you may not have under GDPR. On the other hand, all personal liabilities arise under data security law, including even criminal. Here, we mentioned security. Don't just take it as the routine type of security. So we again talk about security, which means that it has close relevance to political impact of implications. So, talking about criminal offense under this law, we are not in here. It really has quite some gravity and relevance in the Chinese environment. And on the right side box, we try to explain the key part of this law. I mean, how the law is trying to build up a kind of data security framework for the whole country. So in general, the country will build up a kind of grid made of horizontal and also vertical lines where the various ministries, industrial watchdogs, they are going to be tasked with identifying important data, the scoping of important data, and also the different locations, meaning like municipalities. They are also tasked with they are also tasked to find out what will qualify as important data within their respective geographical location. So in the end, the country will build up a kind of important data catalog, and according to which then a company may more easily tell what data will qualify as important data and what not. Currently, this catalog, nationwide catalog, is not yet available. It's yet to be formulated by the various industrial watchdogs, which in the end will become a kind of comprehensive catalog. And also, another aspect to be noted under this law is that the law is not only bringing all those, say, compliance burdens, but there's also positive side that for the first time, this law is promoting big data strategy. We can also see this in the following slides that data trading is also encouraged by this law. So this also, to some extent, also reflects China's strategical positioning in these very specific fields. So now more detail about this law. Again, like the Chinese PIPL, the data security law also takes a long reach approach. meaning that even if you are sitting outside China, but as far as you are processing data which concerns about the national security of China, then you also may be held liable. This sounds indeed a little bit too far-reaching, but this is exactly what is now happening under various Chinese laws. You might have also noted about the recent legislation on the anti-sanction law in China, also the deblocking measures. So in that regard, when facing the various pressures from the outside, the Chinese legislators are also trying to learn from the Europeans to take legislative actions in order to push back the pressures from the outside. And this, in the end, although this kind of long reach might appear as a bit far-reaching, however, for any companies which is internationally deploying and operating, this may indeed hurt you in the end, because they may find difficulties to pursue you when you're sitting outside, but they may find some good legal grounds to pursue and enforce against your PRC assets. So this will be the important impact to be borne in mind. And important data, as we mentioned, that the exact scoping is not fully clear. There are some industrial catalogs, like in the financial sector. There are already scoping of important data, like in the car industries. The regulators already defines what will qualify as important data. However, for the general manufacturing business and also a wider sense business, what qualify as important data, these yet have to wait for the nationwide catalog to be rolled out. And yeah, if you happen to process important data, what could be the new obligations on top? Actually, in general, you will first be subject to those existing obligations under the cybersecurity law, but on the other hand, you may face escalated obligations to keep security of important data. So under this law, it says that first you need to build up, to spend some efforts on organization side, meaning that you need to have a dedicated function and department which should be taking care of data security issues. For international companies, this is not a big problem, but then the more cumbersome part would be the regular risk assessment exercise, which you need to conduct. And this is quite some paperwork and efforts and time to be spent within the organization. And also, more importantly, you need to submit your risk assessment report to the competent authorities on it. And this report needs to outline quite some detail, including category, quantity of data you are processing activities, security exposure, and measures to manage the respective security topics. So in the end, for multinational companies, there could naturally be concern whether or not this might touch upon my trade secret. That could potentially be a challenging area to be examined in more detail in order to better comply with the requirements of this law. For a CIIO, which stands for Critical Information Infrastructure Operator, which is a term defined not really defined, addressed by the earlier cybersecurity law. So for CIIO, if you are processing important data, you will be subject to higher obligations, but for many foreign companies, you might not need to worry about this concept because CIIO usually refer to those conducting sensitive business, which are anyway not possible for foreign companies to be in. So in this regard, you may more or less just ignore CIIO. So trying to move to the next slide. Yeah, minimum compliance requirements. Here, I'm just summarizing what are those addressed under the law. Many of the obligations are already there, and you might not feel unfamiliar with these obligations because many of them are the routine measures to be taken as the routine IT security measures. But what you need to bear in mind is that the first item, it says that data processing activities and new data technology R&D should be in favor of economic and social development and promote welfare of people. So this kind of very high level and vague advocacy is written down under the law, which may indeed create confusion because for all companies, they are supposed to be profit making. However, this law is trying to kick in some more this kind of social responsibility element to, in reality, sometimes this kind of very vague and general principle might even be used against business. But this is just some, maybe a little bit speculating, but in reality, sometimes this may happen. So this is also reflects the political feature of this law. What you need to note is regarding the security reporting obligations. So the law says that in general, you need to report to the authorities whenever there's any security measure. It does not address explicitly what should mean by reporting in a timely manner. However, please note that the regulators, they are taking some new approval which actually touch upon some specific lines when you need to report a particular case. So that remains worth noting. And here I'm trying to use the slide to summarize some key particulars to note under this law. Data security review system under this law, there is a security mechanism which is very similar to the national security review in the investment area. And it's final, so means that any result out of that review, you cannot further go to court for constitutional or other review. So this is something quite new in the data field. Export control, likely as far as we talk about export control in China, may be less relevant to multinational companies. However, it depends because it depends very much on what kind of technology you might be generating in China, particularly if you have heavy R&D activities on the ground. And the law says that data associated with materials which are subject to export control, these should also be subject to data export control. And state secret is carved out explicitly by this law, which is good news. But again, that's to be regulated by a different law. Whistleblowing, this is one important development you need to note under both the data security law and the PIPL, because the Chinese government is using the law to encourage all citizens to data subject to report any incompliance, which could substantially increase potential exposure of multinational companies in China, operating in China. Data trading, this I mentioned earlier, this is quite some positive development because for the first time, national level law is addressing and encouraging data trading, which will mean that for those smart solutions in China, as far as you satisfy regulatory requirements, you may have some better legitimate legal grounds to use that for business. So that's all our slides, and I think would be we already received some questions. So Bing, if it's fine, I'm now just trying to quickly pick up those few questions raised by the audience. Is that the correct sequence?
Well, actually, what we'll do is we'll just maintain the suspense a little bit longer, Michael, and we will come to those questions in just a couple of moments.
Okay.
I do believe we have some polling questions. I think it's worth us just toying on these polling questions for a moment, then we'll come back to those questions and a few more questions that I've had sent in as well. So we will come on to your questions in just a moment. We've promised to do that. But I think it's worth us just polling for a moment as well. And I know this is such a simple question, but I often have some feedback that says actually these simple questions are often so important in terms of gauging where other attendees and businesses are. So I'd love to know from you. Again, this is entirely anonymized and aggregate in its reporting. It just allows you to understand where all your other attendees are. So please do click away. Will this personal information protection law and the data security law apply to your business from what you heard? So it'd be good just to gauge that from you now. So please do click away, yes or no, or the third option is there as well if you're still just not sure whether that applies. So we'd love to have you click away on that. I know there's a lot to digest, but it'd be interesting, and I know a lot of you I can see, those who are attending today, do have operations, you do have a meaningful or an active presence in your services, products, and international lines reaching into China as well. So I'd be intrigued to know what your views are from what you've heard today, and maybe what you've already been looking at as to whether or not this will apply to your business. So let's see what that looks like at the moment. Okay. So interestingly, no one falls into the no category. So we've got a fairly clear 80-20 split here. A vast majority of you think this will apply, and I'm not surprised, but it's good to see that understood here in the polling as well. Although 20% still not sure, and again, not surprising to see that there's a degree of uncertainty, given that this is new, given that this is complex, and also given that there are still some areas that need more explanation, more guidance, and more maturity as we go through. So thank you very much for polling on that. Just a couple more questions to poll, if you would mind. So for those of you who think it does apply, which is a vast majority of you, where are you in terms of compliance? Because this legal regime is now in force. So have you actually taken steps to ensure compliance? So again, just to give everyone a flavor of where maybe our attendees and representative companies are. So yes, if you have taken steps to ensure compliance, or no, if you just haven't done that yet at all, so it's still on the wish list, or yes, it's in progress. So there is a program in play towards compliance. And one of the reasons I'm asking this question is it's slightly loaded from my perspective. As I know in Europe under GDPR, we had a lot of notice that GDPR was coming, and in the end we then had this grace of 2 years, and China has not been as generous from that perspective, and the compliance grace period has been months, not years, and we know how complex that can be to comply. So let's just see what that looks like. Okay, so I'm sure, and hopefully you can see it's coming up on screen. So the vast majority of you are saying, yeah, this is in progress. This is something you have in play, and that's pleasing to see that you have this in progress. Only a small percentage of you are not there at all, but actually a meaningful 17, small but a meaningful percentage there that said, yeah, you've taken those steps to comply. So that's also reassuring. But let's focus on that large 3/4 of you who've said this is actually in progress. I think some of the questions we'll come to in a moment may help you in that state of progress and proceeding on that. Final polling question, if I may. So it's obviously a vague question to say if this is in progress. Let's just benchmark that just for a moment, if we may. It's rather crude, but if you think you've hit 100% on that, we'd love to know. If you think you're almost there and you're 75% plus in terms of those compliance steps that you're trying to progress and reach, or is it something that's above 50% for now? So again, I'd love to know where you believe you are in the compliance steps that you've actually progressed. Remember, over 75% of you were in the category of yes, you are going through the process of taking those compliance steps. So where are you in that at the moment? So let's see where that falls at the moment. Okay, so no one's brave enough, or no one believes that they're at 100%, and I think that's always reassuring to see. But a smaller number of you are above 75%, so quite advanced in that progress and over 80% of you believe you're over 50%. So it's interesting to see where that is in terms of, and I hope it helps you understand as attendees as to where your fellow attendees and the organizations look to be on this. So that's very, very helpful. Let me just turn to some questions, and I may bring Michael and Julian back into this. And yes, we've had some questions come in, and I'll come on to those in a moment because they've been sent in today. If you want to fire another question in, I think there might just be time to squeeze it in too. But let me just focus on some of the questions I had sent in to me earlier. So the first question, and this may be for Michael or Julian or both of you, why should overseas businesses take note of this new law, particularly if there's no presence on the ground in China yet? But obviously, it's a market of significant importance to a business that wants to take advantage of the marketplace in China and what it offers. Can you be as simplistic and say it's low risk for you because you're not in the jurisdiction? Or are there reasons as to why overseas businesses who are not quite yet with a presence on the ground take this seriously? So who's going to go for that?
Well,
Michael?
So allow me to pick this up. Well, I think the answer actually is not so complicated from hypothetical perspective. It's very explicitly addressed under the law. It's similar to GDPR. That is Longreach under both the PIPL and the DSL. Okay, so it applies to offshore activities as far as you have some relevance to China. And then the next more business and practical level question would be that, okay, so how serious is that in reality? Then if you are, I think that would be a question to be asked back to check, with the business. If you are sure that you don't need to have any links with China market, like in the cyber world, we have the great Chinese firework, meaning that you might be hosting some services serving China, but if you are violating law, for sure, the Chinese government, they may simply shut down your services. So that would be some way they can easily pursue you. And if we do encounter some cases recently where our clients, foreign clients, their data business is structured in the cloud, where they expect some Chinese parties to submit data to them across the border. And you may continue with that model. However, you are always facing a risk that first, the Chinese parties might refuse to provide data to you because they are obliged to satisfy the legal requirements. And on the other hand, Chinese government might also have a concern and then might shut down the transmission of data to you. And even if if we talk about any violation of those laws, they may pursue against your Chinese assets. So in the end, in that regard, China is also trying to learn a bit from the Americans. Wherever there's any links and connections, they are trying to make use of that. So in reality, they will find all means to enforce against you.
Okay, thank you, Michael. That's helpful to know. So let's not be naive, I think, is the answer that's coming through, that just because we don't have a presence on the ground, this is something to be taken lightly because of the impact and the practical impact to address and ensure compliance, quite frankly, if you're in the marketplace, albeit remotely. Another question I have is, what's your view on how regulators in China will position the action and how they will position their strategy going forward? Do you think they're going to warn businesses, or do you think they'll push straight to enforcement, or is there something in the middle somewhere?
Well, in that regard, I think there's always some misconception by reading the law that this is some attempt of the Chinese government targeting foreign business. I think that is wrong. And also, in this regard, one thing I would like to get across is please try to focus on try to be too much into the kind of B2G quality that always trying to the government, trying to get some clarity or trying to estimate when they may implement. In fact, you might need to look around, particularly if we in one slide we mentioned that the law is encouraging data science and also the society to do whistleblowing, meaning that a case may more easily get exploded from within, like an unhappy employee, instead of being targeted on the initiative of the regulators. So what we do think would be that, yes, the Chinese government, they still need foreign investment, they still welcome foreign investment. If you are big enough, if you are important enough, they may give you a warning. However, if you did not spend any compliance efforts, and then I think you can be easily targeted. And once there's a small complaint, it may get escalated. We have seen many of those cases where, as far as there are some bigger reasons behind, then a small handle can really blow up a case and turn that into a big one.
Okay, that's interesting, Michael. So I think that often is something that we may not necessarily lead our thinking to in terms of the law that's here. And it seems to be very similar in some ways to what we see in Europe and in the UK, certainly, where the law is also designed to empower the individual and their rights around the data, but also going a little bit further in the context that you mentioned around almost whistleblowing against the organizations that are handling your data. I'm just mindful of time because I do want to get to the questions that are coming. Michael and Julian, if you are okay to stick with us just for a few more minutes, let's have a look at some of the questions that have come in. And maybe we can just fire through some short answers on this to keep everyone's time. One question is, does the DPO have to be located in China? Is there a straightforward answer to a straightforward question?
Yeah. Yeah. Actually, this is a very good and very practical questions we have been asked by many clients about the requirements on the DPO. So as I just mentioned, currently the law is not very clear on whether or not the DPO should be permanently or constantly located in China. This is still not clearly defined under the PIPL. But on the other hand, based on our reading of this PIPL, so the main function of this DPO is to enable the authorities to get access to you in case of any data protection matters. So that means the DPO will act as an interface between the company and the local authorities. So in that regard, we tend to believe that it would be recommendable for the DPO to be located in China to facilitate such kind of a communication between the companies and the authorities. Otherwise, if the DPO is constantly located outside China, maybe the authority may find it hard to reach you via this DPO to manage, to administrate data protection matters. In that case, the authorities may not feel happy about that and may take other actions against you, like implement further investigation against this company or even escalate the situation. So in that regard, it's not recommendable to have that DPO located outside China. But anyway, the general understanding of this question still needs to be revisited because the legal requirements, as we just mentioned, is still developing very dynamically, and the regulators might provide some more detailed requirements for the DPO in the future.
Okay, Julian, that's helpful, and in some ways similar to what we see across Europe and certainly in the UK, where the expectation is that the data protection officer would be in the jurisdiction. But if they're not, we know that some cases that can still work. You need to be prepared to explain to a regulator why. if that arises as well. Okay. Another question is, if an international company is headquartered in the EU, but has a group company in PRC, does it need to appoint that group company as its representative? Who wants to take that question? Is that one for you as well, Julian?
Yeah, I can do that. Yeah, actually, this is still a very good question, but the answer is still not very clear under the PIPL. As I just mentioned, I remember in one PPT slide where I list in a chart the comparison between the PIPL and the GDPR. So currently, detailed requirements on what kind of person should be qualified as a representative for this for a foreign company is still not very clear under the current law. So whether or not such representative should be an individual or an affiliate of an offshore company is still not very clear, which needs to be revisited in the future when more detailed guidelines is promulgated by the authorities. Yeah.
Okay, sure.
On the other hand, just to add that the law also does not say that you need to have equity ties between the local representative and the offshore company. So in general, this also, on the other hand, may mean that you could appoint some external parties as the local representative. I think that's very also similar under GDPR.
Yeah. Okay. Good to know that view, and also, I guess, again, reinforcing that we still need to see how this develops in practice, and again, one to watch. Just two more questions that we'll take very quickly, mindful that we're over time, so maybe we'll wrap up on these two questions. And I say two because actually they're both relating to transfers of data. So the first question, you talked about particularly separate consent requirements. And we're not, when the concept of unbundling consent is not alien to us in Europe and GDPR. There's a big focus and spotlight on consent under GDPR. And you talked also about separate consent requirements. The question here relates to that, I believe, is does a transfer out of China require separate consent to that transfer itself?
Yeah. Maybe let me pick that up. I think indeed this separate consent concept is quite challenging and quite confusing for minds if you are already familiar with GDPR. Even here we are struggling with what it means. But as far as this question is concerned, transfer out of China, separate consent is explicitly required. So regulated under Article 39 of the PIPL. To see that it says, but what exactly means separate consent? Does that mean a separate process, or does that mean a kind of a breakdown, content-wise is separated? So this is not fully specified under the law, but in reality, if you want to do it in a simple way, maybe get both covered separately.
Okay, thank you for that, Michael. And the final question, and we'll wrap up here, is any idea when we will see a draft of the standard data transfer agreement available from the authorities?
Let me pick that up. I mean, but indeed, we have been asked many times. I think it's not logical that the law already took effect November the 1st. However, we still don't have the SSCs in place. But this seems to be the case. So far, there's no this kind of prospects how soon this will be provided. Currently, I mean, from very practical point of view, what we normally recommend to our clients will be that take your GDPR sample as good basis and then cross-check with the Chinese legal requirements. That should give enough comfort because the GDPR samples are already good enough. On the other hand, because there are different versions of SSCs under GDPR, this can become a bit tricky when you are using that in a Chinese context. So in that regard, coming back to the question itself, we do expect this will be coming out soon, but so far from the market, we have not heard of any official announcement or indication when and how soon this will come. So unfortunately, we don't know, more or less.
Okay, excellent. So maybe we will revisit this topic again very soon, and hopefully when we have maybe more answers and some more context on some of the complexities that we've covered here today. So I think that's time probably for us to wrap it up, because I know it's very late, Michael and Julian, for you in China. You're probably ready for bed soon. It's certainly getting late in Europe. I'm late for my lunch, and I know it's still early on the East Coast for our attendees there, so maybe they are ready for their second cup of coffee. But thank you very much to all those who sent in questions today. My thanks to you, Michael and Julian, for your expertise in sharing that today in a very complex piece of legislation to break down and cover. And hopefully when we know more, we will maybe invite you back to share that with our clients and contacts. Again, I know these remote events are great to bring all these people together from different jurisdictions, but remote events wouldn't be the same unless we have these slight connectivity issues at times. So if anyone missed anything or maybe didn't hear anything properly, please feel free to contact me or Michael or Julian, and we'd be very, very happy to talk to you offline on that. So for now, thank you very much for allowing us to overrun, because we wanted to make sure we got your questions in today. But thank you very much for joining us. We hope that you'll join us again very soon for one of our webinars. Look out for those. And if you haven't seen already on the Global Data Hub, the slide that's on the screen for you, you'll be able to access more content. And both Michael and Julian have also written quite a detailed article on this as well. So we have that in writing available for you there as well. But for now, from Wessing in London, from Wessing in Shanghai, thank you very much and goodbye.